The freedom of speech, protected by the First Amendment, is a foundational and cherished right that sets America apart from other constitutional democracies. Many people think of the First Amendment in the context of controversial speech on highly politicized issues. But did you know that some of the most important free speech cases today involve uncontroversial speech? Increasingly, this includes issues that matter most to ordinary Americans in their daily lives. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. Today we have with us IJ senior attorneys Paul Sherman and Robert Johnson to discuss this trend and why it is affecting more and more Americans. This is Beyond the Brief. So Paul, broadly speaking, what is occupational speech?
Occupational speech, most simply put, is just speech that people earn their living by. So, 50 years ago, a lot more people made money by building things, making things. As we've moved to a more information-based economy, more people earn their living through the advice they can give or the information they can provide. But as occupational licensing has grown, more and more of that speech is being subject to government regulation. So occupational speech exists at this intersection of the First Amendment and economic liberty.
So that's a really broad concept, right? So does this just mean that, everything that we do is speech and so nothing can be regulated?
No, it doesn't mean that nothing can be regulated, but it does mean that there's a lot of speech that has historically been underprotected and the courts have not taken as seriously as they should have. Now, that's something that has started to change, in part because of the Institute for Justice's litigation in this area. And one of the things that we want to make clear to courts is that the First Amendment says Congress shall make no law abridging the freedom of speech. It doesn't make distinctions between the categories of speech, whether that's political speech, which has historically gotten more protection, commercial speech, which courts have kind of treated as a second-class citizen, or occupational speech, which has also not gotten the full protection of the First Amendment. So in recent years, the Supreme Court has made clear there is no exception to the First Amendment for so-called professional speech or occupational speech. And in a series of cases, we've tried to show that this means that speech on a wide variety of topics, whether it's diet, engineering, law, health, all of these things are fully protected by the First Amendment.
So, Rob, what does that kind of look like on the ground? Like, how did IJ get involved in this? What are some of these cases that Paul's describing look like?
Yeah, so one of our first cases on this was a while back where the CFTC was actually trying to require a license to publish books about investing. And that was a long time ago. And since then, we've looked at other types of speech that people are doing where they're getting paid for it. So we've had cases about people who are trying to give nutritional advice, people who are trying to give advice about how to care for animals, like veterinary type advice. There was a case about where the government was trying to require a license to publish a newspaper column giving advice about relationships. So this can really span the gamut. We've had also cases about tour guides where the government is trying to require a license to be a tour guide. And like Paul said, the economy is moving in a direction where people are talking more for a living, so it's more and more relevant. And occupational speech, occupational licensing is expanding. And, the thing that drives me crazy is people say, well, how could we have all the protection for this if it's going to interfere with occupational licensing? And I think the response to that is, occupational licensing isn't in the Constitution, but the First Amendment is, right? And that's not a problem. That's just a feature of how the Constitution works.
One of the things that the courts have struggled with in this space is sometimes drawing the line between speech and conduct. Because sometimes, let's just use the tour guide for an example. Obviously, a big part of what they do is speech. But some would argue, well, they're also taking people around the city. That's conduct. So how are we supposed to draw this line between speech and conduct? Is there a bright line rule, or is it more of a case-by-case sort of analysis?
Yeah, so this goes back to what Kim was asking a moment ago. Does this mean that we just can't regulate occupations at all? under the First Amendment? And the answer is no, not every regulation of occupations implicates the First Amendment. And the Supreme Court has established a test for distinguishing when a regulation is a regulation of speech and when it's a regulation of conduct. And this is important because the government, in defending these cases, is always trying to relabel speech as conduct. So, in a case involving veterinary advice, they'll say, oh, this isn't speech. This is the conduct of practicing veterinary medicine. Or this isn't speech. This is the conduct of practicing therapy. The test the Supreme Court has set forth says even when a law is generally aimed at conduct, like the conduct of veterinary medicine, you have to look at the particular application that is triggering the law. And if that application is triggered by speech communicating a message, then that application has to be analyzed under the First Amendment. So a law that regulates the practice of veterinary medicine, if it's triggered by, say, veterinary surgery, that doesn't implicate the First Amendment. If it's triggered by giving someone advice or information on how to take care of their animal, that does implicate the First Amendment.
Let me ask a quick follow-up question that's probably obvious to any lawyers who are listening, but maybe not as obvious to others. When you subject a law to First Amendment scrutiny, that doesn't mean that the law is automatically struck down, right?
That's exactly right. And this is a common misconception. Holding that the First Amendment applies to speech does not mean that every possible regulation of that law, of that speech, is unconstitutional. But it does mean that the government has a significant burden that it has to satisfy. The government has to show that there's a real problem, that it has a compelling interest in mitigating that problem, and that the means it has chosen to mitigate that problem burdens as little speech as possible. Now, there are all kinds of ways that the government can try to get at the problems that it gets at with occupational licensing that do not involve prohibiting broad classes of people from speaking. The government could, for example, require people to disclose that they don't have a veterinary degree if they give advice about specific animals. That would be a more narrowly tailored way that would still allow people to speak and would still allow consumers to decide for themselves which speakers they want to listen to.
So to go back to the sort of distinction between speech and conduct that you mentioned earlier, we get accused of trying to, make it so that you can't regulate lawyers at all, or you can't regulate doctors at all, right? And that's obviously not what we're trying to do, but I wonder if this speech versus conduct kind of distinction kind of helps clarify that line at all. Can you kind of explain that?
Yeah, so for instance, with lawyers, right? Like a lawyer, if you are appearing in court, you're appearing in a particular forum, has speech elements to it for sure, but there's also a conduct element of standing there and representing a particular client. Definitely other things that lawyers do, like handling client funds, like no question, handling client funds, that's conduct, it's not speech. But then there's other things that lawyers do, like giving people advice about their legal obligations, things like telling people, this is how you might write a brief about this type of an issue. This is how you might structure a transaction, to comply with the law. That's just speech. And, at the end of the day, right, the government takes this view that, well, this is important speech that people might rely on. This is speech that actually might be valuable to people. And, well, that can't possibly be protected by the First Amendment. But that's completely backwards.
Yeah, a good way to understand this distinction is to think about a doctor's prescription. So if a doctor recommends to you, I think you would benefit from taking this medicine, that's just speech. If a doctor writes a prescription, that's carried out through speech. He's writing a message and communicating that to the pharmacist. But the prescription also creates a legal entitlement to access a controlled substance. So when the government says you have to be a licensed doctor to write a prescription, what it's regulating isn't the speech, it's regulating the creation of that legal entitlement to access the drug. And it's very much the same when you're talking about lawyers. A lawyer can give advice, that's just speech. When a lawyer is appearing in court, he's acting as an agent of his client and can bind his client to the representations he makes to the court. And that's really what you're regulating in that instance.
So let's look at some specific examples. We recently filed a case in North Carolina where paralegals want to be able to give advice without the supervision of a lawyer. And those paralegals, by the way, professionally give out that same advice when they're, acting in their own capacity at their law firms. So can you tell us a little bit about that case and what's going on there?
Yeah, so we represent a group called the North Carolina Justice for All Project, and also some of its members who are North Carolina certified paralegals. So that's a voluntary certification for paralegals that's made available through the state bar. And what they want to help people do is fill out court-created legal forms. So these are forms that the courts publish and put out to the public for North Carolinians to fill out on their own without the help of a lawyer to do basic legal things: uncontested divorces, custody modifications, civil no contact orders, responding to evictions, these kinds of things that are sort of the bread and butter of daily life in the courts. These forms are intended for people to fill out without the help of a lawyer, but if you've never had any interaction with the legal system, they can be confusing. It's easy to make mistakes. And even if those mistakes don't permanently prejudice your rights, they can slow things down. They can keep you from resolving your legal issues as quickly as you would like. So what the North Carolina Justice for All Project would like to do is host free legal clinics where they can assist people in filling out these forms. Now, a lot of the members of the North Carolina Justice for All Project have filled out these kinds of forms hundreds of times. They know exactly how to fill them out. They know where you can go wrong. And again, they're not complicated. But under North Carolina law, filling out these forms or advising someone on how to fill out these forms is the practice of law. And you can only do it if you are a North Carolina licensed attorney. Contrast this with the way that our closest legal cousins, England and Wales, regulate this sort of thing. Across the pond, you don't have to be a lawyer to give legal advice. I could move to England tomorrow and hang out my shingle and be Paul Sherman, legal advisor, and advise people on, I guess I'd advise them on American constitutional law. I don't know how much use it would be, but I could do that. Instead, what England does is it regulates certain legal conduct, like initiating litigation, appearing in court, certain kinds of property transfers and things like that. You need a license to do those things, but you don't need a license just to give advice. And so what we've argued in this case is the government has less restrictive alternatives to prohibiting our clients from giving this speech. So they want to be able to do that both for free and for pay, because another important principle is that the mere fact that someone is paid for their speech does not reduce the level of First Amendment protection it gets.
And the thing that's so great about that case is we have such a shortage of legal services in this country right now where people just literally cannot get access to a lawyer. They can't get access to information about how to deal with this kind of case. And what the government's basically saying is, well, either you can have like the Cadillac of legal representation, like a lawyer who's had, 3 years of law school and plus 4 years of undergrad, like this super overeducated person, or you can have nothing at all.
Yeah, you can go it your own with Google or with ChatGPT, and we know that there's some pitfalls to doing that. Or you can hire a lawyer. And for many people, not just the poor, that means going without, because there is this group that we call the missing middle, who are people who make too much money to qualify for free legal services like legal aid, but not enough money that they can afford to pay the high prices that lawyers charge for their services.
Some of our critics in this space, and mostly academics, tend to criticize this type of work as being, quote unquote, First Amendment opportunism, as though seeking to vindicate First Amendment rights is somehow a bad thing. And they argue from this position that the First Amendment has been understood to protect certain kinds of political speech, right? It's this idea that the founders were concerned mostly with ensuring that, you could pamphleteer and you could, stand up against tyranny. How do you respond to those sorts of criticisms that seem to want to limit the First Amendment to a very unspoken, narrow category of speech?
Yeah, well, so I would say first, it is opportunistic, right? The Supreme Court right now, there has never been a better time in American history to be litigating First Amendment cases because it is one of the few rights in the Constitution that the court consistently takes seriously. And so, of course, we're going to use that tool to try and vindicate people's rights. As for this view that the First Amendment should be limited to just political speech, or this is a view commonly associated with, for example, former dean of Yale Law School, Robert Post, this idea that the First Amendment is about democratic self-governance. That's surely an important part of the First Amendment. It doesn't reflect the way the Supreme Court has treated the First Amendment for almost 30 years. Over the last 30 years, the Supreme Court has taken a much more libertarian view of the First Amendment as being about speech generally. And I think this is an important view because people do not simply live political lives. We live commercial lives. We live occupational lives. And for a lot of people, advice on how to modify a custody agreement or how to get a civil no contact order against an abusive ex-boyfriend is far more important than advice on who they should vote for in the next presidential election. And I think it's no less deserving of full First Amendment protection.
I would also just observe that a lot of those same people seem to think that the government should have extra leeway to regulate political speech because they think that political speech is a problem too. So, I'm not sure that criticism is very fair.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So we started doing these occupational speech cases decades ago at this point. How has the court sort of changed how it approaches this? You talked about the Supreme Court, for a long time has really kind of taken the First Amendment seriously in a way it's not taking other things seriously. But, how far have we come, basically, and what's happened since we kind of started this area?
Well, so for a long time, the Supreme Court had just said nothing about this area. There was a single case from 1985 called Lowe versus Securities Exchange Commission. It was about a disgraced former investment advisor who had started publishing a newsletter. The SEC went after him for that. They said he had to be registered with the government to do it. It went up to the Supreme Court, and the Supreme Court ended up resolving it just on statutory grounds and saying the law didn't apply to him. There's a concurrence in that case by former Justice Byron White, where he thought that he had to reach the First Amendment question, and he sort of made up this test that the First Amendment applies with full force if you're talking to kind of the world at large, but it doesn't apply if you're giving individualized advice to a specific person. This really had no basis in anything the Supreme Court had ever said. It was never adopted by any other justice of the Supreme Court, but it was also the only thing that anyone on the court had ever said about it. And it ended up having this outsized influence on the lower federal courts. And so circuit courts started to adopt this so-called professional speech doctrine. And it proliferated until about 6 years ago, when in a case called National Institute of Family and Life Advocates v. Becerra, the Supreme Court repudiated that doctrine. And it said there is no professional speech doctrine. We have never acknowledged one. There are a handful of categories of speech, things like defamation, obscenity, child pornography, fighting words that we have recognized as unprotected, but we don't add to that list liberally. You have to show that something has been unprotected from the time the First Amendment was enacted in order for it to be on that list. And occupational speech isn't one of those things. With that clarification, that really vindicated the arguments that we had been making, because we had been trying to show, this concurrence is not the law. It's inconsistent with everything else the Supreme Court is saying. Finally, we were vindicated. But even in the wake of that decision, lower federal courts are really resisting it and pushing back and trying to re-import this professional speech doctrine through things like this distinction between conduct and speech. So an important part of our litigation efforts is to push back against that and also to create the circuit splits that will get this issue back to the U.S. Supreme Court so that it can really definitively say that there is no occupational licensing exception to the First Amendment.
So How do courts kind of deal with this today? It seems sort of, like a difficult thing for them to kind of weave their way through. So I wonder if you can talk about, how courts are kind of dealing with this. We recently got a preliminary injunction in California. Maybe that's an interesting example.
Yeah, so in California, we sued to challenge a requirement that people who, we have a client who his job is reading through people's emails and then identifying emails that are potentially illegal spam, right? So you can sue about spam emails, junk clogging up your inbox. And then he tells people that these are potentially actionable, they can sue about them, and they can, potentially make a bit of money off of that. And our client, the state of California, told him had to be licensed as a private detective because he was investigating emails. And we sued and we said, first off, this is speech, right? He's reading and then he's talking, and that's all he does, like literally all he does. He could, he does his job on a laptop, right? And then the other thing we said is this makes no sense. This is completely irrational because to become a private detective, you have to study things like how to use a gun or how to, tail a suspect in their car or how to wiretap a phone, things that have nothing to do with what this guy is trying to do.
And it's quite a few hours too, right? I mean, it's not a small licensure requirement, is it?
No, it's not. And he was required to, in California, to apprentice himself to another private detective for, a matter of years, and in order to become licensed. So he basically would have to walk away from this business, go, apprentice himself to Dick Tracy. And then when he was done with that, he could come back and restart his business all over again. And so this makes no sense. And so to answer your question, right, the court looks at this, and the court actually said it's not speech, it's just conduct, which, we think is wrong. But I think is reflective of the kind of confusion that we're seeing in the lower courts that Paul's talking about. But then it said actually that we got a preliminary injunction anyway in joining the application of this law because this is so irrational that it violates what's called the rational basis test, which is the kind of baseline level of rationality that all laws have to have, whether they apply to speech or conduct.
And we have a new case in Illinois that's sort of a similar situation where a client is being required to become a private detective or something to do a completely unrelated job. Can you tell us about that one?
Yeah, so our client in that case, he actually is in California, but the case is in Illinois. He's a gentleman in California who has a business helping people file claims for what's called unclaimed property. So if you have a bank account, for instance, and you move and there's, you just kind of lose track of your bank account, that becomes what's called unclaimed property. And eventually it goes to the state, and the state holds it in trust. And if you file a claim for it, they're supposed to give it back to you. So there's things like bank accounts. There's also things like checks that just, somehow it gets lost in the mail. Nobody ever claims the check. It goes to the state. Rebates from your phone company, just all kinds of things like this. And what he does is he actually just will go to states all across the country, and he'll look through these databases, and he'll identify property that people are allowed to claim, and then he tells them about it, and he helps them file the claim for the property. Super helpful service. And by the way, the states hate this because the states want to keep the property, right? So states keep, like Illinois has $5 billion in unclaimed property that it's just holding, and it actually recently passed a law that it's going to start using this to fund its pension obligations. So, this is money that the government wants to keep, and it's trying to impose barriers. So what a number of states have done is said, if you want to file these types of unclaimed property claims, you have to be licensed as a private detective. So all the same problems that we saw in California, where this has, private detective licensing has nothing to do with filing claims for unclaimed property. It's about firearms and surveillance and whatnot. So we filed a First Amendment challenge there, essentially mirroring the arguments that we made in the California spam emails case.
Yeah, and one of the things we try to do is bring cases in multiple jurisdictions that have similar facts challenging similar kinds of laws, because that increases the possibility of getting a really clean circuit split, a really clean disagreement between the courts. And those are the kinds of issues that the Supreme Court is most likely to take up.
When I hear about these cases and I think about the future, one of the subjects that comes to mind, to me at least, is AI and AI-generated content. Obviously, artificial intelligences don't have First Amendment rights, but the people who use them do. And I'm curious how those sorts of tools are going to interact with the First Amendment moving forward. Paul, I know you've recently submitted a comment in response to a proposed Fifth Circuit rule that dealt with lawyers and whether they were using AI-generated content. How is this new burgeoning technology going to interact with the First Amendment?
Yeah, I think it raises some really interesting First Amendment questions. Some of them go to occupational speech. Some of them are completely separate issues. I mean, there's going to be the issue of things like deep fakes in political campaigns. This is already something that I think has come up in some campaigns overseas. And I think we're going to see it in American campaigns soon. And how is the government going to approach that? In terms of occupational licensing, one of the things that we have seen is that lawyers have started to use these generative AI platforms in writing their briefs, and not all of them have done so responsibly. Generative AI can't think. It just sort of predicts what's going to come next in a sentence, and that means that it can make things up. And one of the things that it has made up is legal citations to non-existent cases, and attorneys have gotten in trouble. Courts are trying to figure out how to deal with this. What we have suggested in our comments is that courts already have the tools for dealing with this. It's really no different from any other kind of sloppy legal work that violates an attorney's ethical duties. But I think a more interesting question is, what about non-lawyers who use these tools when they represent themselves pro se? How is the law going to deal with that? And I think one kind of heavy-handed approach would be to try and prohibit non-lawyers from using this kind of thing. But the interesting thing is that lawyers are going to use these tools. And in fact, here at the Institute for Justice, we use these tools through some of the legal research platforms that we use. They've started to incorporate AI. And you're going to end up, if we're not careful, with this very two-tiered system where lawyers are going to be able to use generative AI, and non-lawyers are going to be stuck using Google, basically. And then there's also the question of if these platforms can write legal pleadings better than non-lawyers could on their own, that could potentially make it a lot easier for non-lawyers to vindicate their rights in court. But that also means that the volume of work in the courts could go up exponentially. And how are courts going to handle that new increased volume of work? So it's going to be a big deal. I don't think there's any getting around that.
So far we've talked about some pretty technical examples of, lawyers and things and even some things of like, how do you misplace a bank account are pretty hard things to kind of relate to for an average person. So how does some of this kind of impact regular people's kind of day-to-day lives?
Well, I mean, as we mentioned earlier, there's all kinds of occupations. Most occupations involve some component that is speaking. And this doesn't just apply to people who are out there wanting to earn their living by speaking, whether it's as a tour guide or as a therapist or as someone giving veterinary advice. It applies to all of us as consumers in trying to seek out information and advice from the sources that we trust. Maybe we want to go to a state licensed dietitian when we want dietary advice, but maybe we want to go to a privately certified diet coach or someone who focuses on the keto diet or the paleo diet or the whole 30 diet or any of these diets. We as consumers should have that choice. The government shouldn't get to decide for us which sources of information we get to consider, in the same way that the government doesn't get to decide what books we're allowed to read.
So I guess we can just close by sort of talking about, what the future looks like here, kind of outside of the AI context. You, Paul, mentioned at the beginning that, our economy is becoming much more speech-based and much less, I build things based. I don't know the word for that. But and so what does the future kind of look like here?
I think a big part of this is, again, we're not saying that this is like the radical world where nothing can be regulated. What we're saying is that the government, if it's going to regulate speech, it has to have a good reason, and it has to make sure that there aren't less restrictive alternatives. And so what the future here really looks like is a world where if the government is regulating people's speech, including speech they do for a living, the government has to have an explanation for why it's doing it, and it has to regulate it in a way that makes sense.
Yeah, and I would even say that if you want to understand what the future regulation of speech is going to look like, you could look at the way we regulate books, right? We don't regulate who's allowed to write books on any topic. Anyone's allowed to write a book on any topic, and people are allowed to decide if they want to buy that book and consider the message. People aren't allowed to fraudulently claim that they have credentials that they don't have. That's fraud. That's not protected by the First Amendment. But there's really no reason and no basis in First Amendment law for treating advice that people give one-on-one any different than we treat the advice that people publish in books or on the internet every day.
Yeah, and the point about credentialing is a hugely important one, right? So, a lot of what people look to licensing to do is just to kind of verify that this is a person who, maybe has a certain degree or a certain kind of training. And nobody is saying that you can't do that, right? What you can't do is shut down people who don't have the credential and say, well, you can't even talk at all, right? So if you want to go to a licensed dietitian, great, But what you can't do is you can't say, well, this other person isn't a licensed dietitian, so they just have to shut up.
That makes sense. Well, thank you so much, guys, for joining us, and we'll look forward to seeing how these cases turn out. Thanks for having us.
Thanks for tuning in to today's episode. Now let's take a look at some of our comments from our last episode on SWAT raids. Franimus writes, would this mean the city might have to pay for water damage from putting out a fire? What about for breaking down doors to save people when the door was going to burn up anyway? Well, another great question from Franimus. The short answer is no. We don't believe the Takings Clause requires the government to recompensate homeowners when they put out a house fire or break down the door to save those inside. The reason for that, as you smartly hint at in your framing of the question, is that the person's home is already being severely damaged by fire. Because the home would be completely lost without swift intervention by firefighters, the homeowner cannot show they are harmed when the government causes comparatively less damage trying to save their home or their lives. By contrast, neither Vicki Baker nor her McKinney, Texas home was under imminent threat when SWAT officers filled her home with tear gas, causing her tens of thousands of dollars in damages. Those officers made the deliberate choice to cause that damage in carrying out their duties. Now, the Fourth Amendment may have permitted them to do that, but the Fifth Amendment says they have to pay for it. Prozaric writes, geez, the city of McKinney must have spent more money litigating than just compensating the homeowner. Well, you're probably right. Unfortunately, too many government officials would rather spend more taxpayer money arguing that they're right than spend less taxpayer money admitting they're wrong. You decide whether that's good government. Christopher Helgerson writes, I will never stop donating to these great lawyers, and we at IJ will never stop being grateful for the support you and our other donors provide, Christopher. We are honored by the support you provide with your hard-earned money, and we promise to work equally hard to ensure that your donation helps make the world a better, freer place. Lil Cozy writes, the solution to this is easy. Police departments should be required to have insurance in the event they break the wrong door down, and an increase on their rates every time they claim. If they force me to have car insurance, I'll force them to have wrong house insurance. Well, that's a great point. Interestingly enough, nearly all municipalities have that kind of insurance for damages caused by their employees, including police. But they, and often their insurers, still fight tooth and nail when you or I try to hold them accountable. In fact, one of the most common arguments bureaucrats raise against our legislative efforts to end qualified immunity is that it would make municipal insurance premiums too high. Of course, the facts don't bear that out. Since New Mexico enacted groundbreaking legislation effectively ending qualified immunity in the state in 2021, legislation, I might add, that largely mirrored IJ's model bill, municipalities have had no problem paying and mitigating those insurance premiums. More fundamentally, though, if municipalities genuinely believe that their employees are committing so many constitutional violations that requiring basic legal accountability would render municipalities uninsurable, then maybe their disregard for the Constitution, not accountability, is the real problem. Go Gearhead writes, regarding the side discussion on Monell, many videos show officers demanding ID because it is our department policy, even in cases which do not have reasonable articulable suspicion for detention, and in states which have no stop and ID law. My question is that kind of statement useful evidence for a Monell claim? Well, that's a really interesting question. I think those sorts of statements can be evidence of a policy under Monell. But the issue with your hypothetical is that it's not necessarily unconstitutional for police to stop and ask someone to produce identification. It may be in some circumstances, sure, but the mere fact that department policy may conflict with state law is not, by itself, a federal constitutional violation. It may violate state law, but that's outside the scope of Monell. Gunny G writes, the problem is the bar is set too low for no-knock warrants. They do not need no-knock warrants in most cases. I think you're absolutely right, Gunny. Since government started authorizing no-knock warrants in the 60s and 70s, law enforcement has utilized them on a far too regular basis, often with tragic consequences, as Breonna Taylor's death in 2020 illustrated. The framers of the Constitution intended the Fourth Amendment's warrant requirement to protect the sanctity of a person's home, and no-knock raids undermine that promise. If you're interested in reading more about this and other problems with the modern militarization of law enforcement, consider checking out Radley Balco's 2013 book, Rise of the Warrior Cop. It's a powerful and illuminating read. Thanks again for watching today's episode, and make sure and tune in next time.